Hi everyone, my name is Chase Keebler and I'm the managing attorney and founder here at the Keebler Law Group. I'm here today to talk a little bit about our antitrust practice and in particular about how our opt-out cases work. I started my practice years ago really emphasizing on prosecuting antitrust cartels, and these are not drug smuggling cartels, but they are price fixing cartels. A little bit less interesting, but I still find it incredibly interesting. I love getting into the weeds on the industry specifics for each industry and just kind of how the components and the pieces of the conspiracy that are put together. And I have significant experience doing both of those things, kind of diving deep into the conspiracy and as well as the defendant's industry in particular. I have experience in prosecuting both price fixing and bid rigging cartels. And these cartels cover a broad range of industries. I mean, you really name it, competitors can fix prices on it. My experiences include in the transportation industry, which includes ocean shipping, it includes railroads, and then even in for day-to-day commodities, things you find in the grocery store like pork and beef and chicken, and a number of commodities exchanged on the London Metal Exchange. Really, the possibilities are endless for price fixing cartels, and I'm here to help walk through buyers and protected or possibly impacted individuals who are affected by those cartels. Now, I will say that these cartels are getting much more sophisticated. The ways and means in which they can communicate with each other has evolved. It's no longer just picking up the phone or sending an email. They're becoming a little bit more sophisticated in how they speak to each other, and this makes it much more difficult to catch and prove. But there are methods and technologies and discovery that I have experience in handling to how to get into the weeds on some of those particular communications. And I also kind of want to say how these conspiracies are not bright and dead, not white and black, right? It's not just two competitors meeting and saying, let's raise the price of a widget by $10. Instead, there's many complex mechanisms that could form an agreement to fix a price. There could be capacity restriction agreements, which means competitors say, okay, let's both agree to make fewer widgets in order to raise the price. There are a variety of different bid rigging mechanisms where competitors can come and form a joint venture to ultimately place an anti-competitive bid. There's a number of different avenues and concoctions that competitors can scheme up to make enforce anti-competitive behavior on their customers. And I think it's important to emphasize how the U.S. and most other countries have really strict anti-competitive statutes that make all of these types of agreements, whether it's price fixing, bid rigging, or market allocation agreements, per se illegal. And these statutes typically come with a big stick. Both the corporate defendant and individuals who are found to have violated these statutes can face criminal penalties and even jail time. Now, a civil stick for us is that after a jury determines that a defendant or a group of defendants had violated the antitrust statutes, the judge then trebles or multiplies by 3 any verdict that the jury has decided. In addition, we also get attorney's fees. So this is a real big stick that defendants are afraid of, and for a good reason. So say, for example, a jury finds that a group of defendants had agreed to limit the production of a certain product, and it impacted you, the client, by $10 million. Now, a jury doesn't know this fact, but a jury finds that you are impacted $10 million. They award you $10 million. The judge goes back and he multiplies it by 3 right off the bat. So your award goes from $10 million to $30 million. Now, on top of that, you also get attorney's fees. Now, I have experience representing clients like I said, in a number of industries. And really that's what I love about this practice is I get to do a deep dive into both my client's industry and the defendant's industry to kind of learn how they interact with each other, how the pricing mechanisms work, and just kind of different facets of the inner workings of these industries. Now, the majority of my cases that I handle are what I call opt-out cases. So this is whenever you opt out of a class action. Now, typically, the way you see this happening is just the whole big picture, right? So you see the DOJ will file an investigation, in a public statement or in an indictment or something like that into a particular industry. Soon after, you'll see class lawyers following. And we, as soon as the DOJ issues their indictment or statement, we will monitor that industry and we will look for the largest purchasers of the impacted product. And we will keep them informed of both the DOJ's investigation as well as the class actions following suit. Typically, there's a direct action class, an indirect class, and depending on the market or industry, there could be a consumer indirect action class. Now, what I mean by opt-out is you will not join that class. Rather, you will file an opt-out from the class action. And there's two triggers for that opt-out class action. The first and most common is whenever a court certifies a class action, say a direct purchaser plaintiff class action is certified, then they must notify all potential impacted parties, like you who purchased widgets directly from defendants, that you can either stay in the class or opt out, or there's a number of other options there, but those are the two that really matter, right? So if you want to opt out of the class, you must fill out that form and opt out. That's way one that kind of triggers the opt-out deadline. The second trigger is before class certification. Oftentimes these defendants will settle, and that's typically because of either known liability, they're a leniency applicant with the DOJ. It could be for a number of reasons. But whenever they settle before class certification, they also have to send notice to impacted purchasers like yourself to either stay within that settlement or opt out and sue directly. Now, we represent clients who opt out and sue directly, and they are known as direct action plaintiffs, or DAPs. Now, DAPs claims are told, meaning the statute of limitations no longer continues to run once up and until a class is certified. So that's kind of whenever your clock starts ticking again. That's not to say we won't strategically file before class cert even. Oftentimes we have that happen just to kind of keep in line with the class and prosecute the case on our own instead of prosecuting kind of behind the class. Now, if you have any questions about kind of the opt-out, our opt-out practice or our antitrust practice, please don't hesitate to reach out to me. As far as our opt-out practice, kind of the biggest thing that we look at, whether it's worth it or not to opt out, is the volume of impacted commerce that you have for the particular product or item that defendants had increased prices on. If that volume of commerce or that volume of purchase data is not very high, sometimes it's not worth your effort to prosecute individually, but rather you're better off just staying with the class. Now, I will say that opting out of classes typically gets a much better result for clients than they would have received from staying in the class. And we've tried to quantify this, and it's difficult to some extent, but it looks like over 30% better, if not more, than staying in the class. And again, I'm happy to kind of run through any numbers or questions that you might have and give you kind of an estimate on the types of damages that we have. Now, the Keebler Law Group, we have the resources and the foundation in place to prosecute these types of claims. We have a network of attorneys and technologies and resources that we rely on to best proceed for you and on your behalf. We have contacts and communications, and we work really closely with litigation funders. If that is something that interests you, feel free to reach out to me, and I'm happy to kind of explain and walk you through that process. But again, my name is Chase Keebler. I appreciate you getting to know a little bit more about our antitrust practice and our opt-out practice. If you have any questions, my website has a number of different ways that you can reach out to me, whether it's by phone or fill out our general intake form, and someone gets back to you. We try to do it the same day, but no later than 24 hours. And you can always send me an email. My email is chase@keeblerlawgroup.com. Again, I appreciate you taking the time, and I hope to hear from you soon. Thanks.